All right. Good evening, everyone. I would like to welcome everyone on behalf of latestlaws.com and Indian Dispute Resolution Center to today's valedictory ceremony of First National ADR Tournament 2022. I am Divyan Sanurathi, Managing Partner at Lexidum and Rathi and founder at latestlaws.com. I would like to welcome Honorable Justice V.V. Prasoon, former Judge Punjab and Haryana High Court, Honorable Justice J.R. Midha, former Judge High Court of Delhi, and participants of the tournament as well as the viewers to the valedictory ceremony and the prize giving ceremony. This valedictory ceremony is also being broadcasted live on our Latest Laws Facebook page and YouTube channel. Now, I would like to invite Ms. Sumedha Sindhu, Member Advisory Board, Indian Dispute Resolution Center, and editor latestlaws.com, to deliver the welcome address of the event. Over to you, Sumedha.
Thank you, Divyansh. Good evening, everyone. The team at the Indian Dispute Resolution Center and latestlaws.com would like to welcome everyone to the valedictory ceremony of the first National ADR Tournament 2022. The ADR problem for the competition was on contemporary legal issues relating to construction arbitration. Eminent judges, lawyers of the highest standing in India converged to adjudicate the various rounds of the competition. Now, I would like to give a brief introduction about latestlaws.com. Latestlaws.com is one of the leading law websites in India, which provides the users with the largest free downloadable database of central and state barracks, daily legal updates, legal articles, Supreme Court judgments, and much more. Latestlaws.com has more than 1.5 million monthly users and has a viewership in more than 150 countries around the world. All the legal updates are also posted on Latest Laws Facebook page, which is followed by more than 4.5 lakh people, which makes latestlaws.com the most followed legal website of the country. Latest Laws has also launched its Android and iOS mobile applications, which have more than 4 lakh downloads. The USP of the app is that they provide users with free barracks, that too in offline mode, along with all the latest legal updates. Our mission at Latest Laws is to provide a digital platform which is most informative, useful, reliable, and handy source of laws, legal news, articles, templates of legal documents, and other related information. Latest Laws organizes various seminars, webinars, workshops, and interactive sessions on various legal aspects and concepts which are conducted by the experts in their respective fields of practice. Now, coming to our arbitration institution, the Indian Dispute Resolution Center. The IDRC has been established as a not-for-profit arbitral mediation and conciliation institution so that it can function as an independent international organization with its own progressive ADR rules. IDRC is also registered with Niti Aayog and empaneled with the Ministry of Law and Justice, Government of India. The IDRC was inaugurated by Justice A.K. Sikri on 22nd May 2020. It is the first of its kind institutional ADR center, which provides all the ADR components under one roof. The IDRC provides a unique blend of both offline as well as online ADR platforms. We have state-of-the-art infrastructure for arbitration, mediation, conciliation, as also for early mutual evaluation and expert determination, all of which is done in a time-bound and cost-effective manner. The indigenously developed eADR software also has the facility for digital signature and uploading of claim petitions, replies, and other miscellaneous applications and documents on secure cloud servers with 24/7 access to stakeholders and lawyers. The proceeding sheets are created, e-signed, and saved online with auto-triggered sharing via email with the parties concerned. The IDRC's panel of domestic arbitrators and mediators come from a wide spectrum of fields and comprise of retired Supreme Court judges, retired High Court judges, District Court judges, senior advocates, ex-PSU heads, chartered accountants, and others. IDRC's overseas arbitrators consist of Queen's counsels, barristers, solicitors from London, Singapore, Malaysia, and other countries. Empanelment positions are offered only by way of invitation to the best dispute resolution professionals. For more information, one can visit the website theidrc.com. Now, I would like to introduce our guest of honor for today for delivering the keynote address, Honorable Justice Midha, former Judge, High Court of Delhi. Justice Midha served as the judge of the Delhi High Court from April 2008 to July 2021. As a judge, Lordship presided over several jurisdictions, including judge in charge of original site of the Delhi High Court. Lordship served as the chairperson of Delhi International Arbitration Center. Prior to his elevation, Lordship practiced for over 26 years from 1982 to 2008. From 1989 to 1992, Lordship taught at the Campus Law Center, Faculty of Law, Delhi University. May I now request Lordship to please deliver his keynote address. Lordship, please.
Thank you very much, Honorable Justice Prasoon, Mr. Divyansh Rathi, Sumedha, all the organizers. I first compliment the organizers for conducting a very nice this moot court problem, and also compliment them for selecting a very simple but an innovative problem for the participants. You see, most of the time when we see the moot courts these days, my experience is that the moot court problem is made such a complicated problem that it goes beyond the basic understanding of the facts. And probably this is the first time when I'm seeing a very nice, innovative, simple problem in which both the participants had good opportunity to present their case. I'm told 20 teams have participated, and the results would be declared shortly, and by Justice Prasoon. And since the problem relates to the computation of damages, I'll share my views on computation of damages, which is a very, you can say, which is an issue which arises more often on in all the arbitration proceedings, where one of the parties commit a breach and the other party claims damages, and invariably the question arises how to compute the damages. One thing which I have seen, and also there was a case on the bench before me, where one party committed the breach and the other party claimed damages for there was a contract for shipping contract, where one of the parties had contracted with the other to provide the ships, and the other party agreed to take the shipping services, and the contract was for a specific period. But before the expiry of the period, the other party terminated the contract, and the damages were claimed by the other party on the ground that if the contract would have continued, then X amount would have been earned by them during that period. And the arbitration proceedings were initiated, and the compensation was also awarded on that basis, that if the other party would have performed the contract for the remaining period, then X amount would have been earned by them, which amount was determined from the contract itself. But my view here is that this approach of claiming damages on that amount is not the correct approach. That is the amount which the gross amount which the other party would have received in the event of the contract being terminated prematurely. But that out of that amount, the other party would have spent the amount under various heads for performance. And therefore, we have to see ultimately what is the amount which they show on that income as a profit. For example, taking a very simple example, that if the profits after computation of all the expenses and all the services, everything, ultimately a person is making profit of say 10% or 8% of the total gross receipts, then the loss of that party is not 100 rupees, but it is only 8 rupees or 10 rupees, whatever is the profit they would have earned. Therefore, the computation of profits on the basis of the amount provided in the contract is not a measure of damages which the other side would have received. Even if the other side would have received 100 rupees during the period, if the contract would have continued, the out of 100 rupees, they would have spent 90 or 92 rupees, and the loss of profit would have been only 8 rupees. So, but this approach invariably is not found in the cases. Therefore, I thought I'll share this view on this platform, that this should be the approach that we should find out, and as to what is the quantum of damages to which the other person would be entitled. And this is what if the matter goes to arbitration or it goes to the court, then this should be the approach to compute the damages. Therefore, even if the entire amount which the other side claims that they would have received if the contract would have continued, that amount is not the measure of damages. That is only the amount which they would have received, and then after performance, what is the amount they would have received, they would have saved. Now, this will take it to a next level. Now, let's assume if a company is suffering losses, and for every 100 rupees which they earn, they are spending 110 rupees and suffering a loss of 10 rupees. Then also that will be a very important factor to see. And the amount of damages may be in that case very negligible or token damages, because the actual amount which that person is receiving but is overspending and is not saving any amount, so there is no loss of profit. So this approach, to my mind, should be adopted by the arbitrators as well as by the councils, whether the matter goes to the arbitration or goes to the court, to which we should measure the damages. Then, since this is a platform for arbitration, there is one more area which I would like to discuss before I hand over the mic to Justice Prasoon. Is one of the grounds in Section 34 of the Arbitration and Conciliation Act. All of you are aware that the award of an arbitrator is challenged under Section 34 of the Arbitration and Conciliation Act, and the scope of Section 34 is very narrow. Even a factual inaccuracy in a decision, the court would not go into. It is well settled that it is not an appeal. The scope is very, very narrow, and the court would not even go into the factual inaccuracies. Or if two views are possible and one view is taken, even in that case, the court would not interfere. But on one hand, whereas the scope of 34 is very narrow, there is another back door which is there, because the definition says that if the award is against most basic notions of justice or morality, then it is liable to be set aside. It comes in the definition of the explanation given on the public policy. So the words morality, just most basic notions of morality or justice, have been defined by the Supreme Court in Associate Builders case, where the Supreme Court said that morality here is not morality of moral turpitude. Most basic notions of morality or justice means that which pricks the conscience of the court. So anything which pricks the conscience of the court would set aside the award as being against most basic notions of morality or justice, which is a very, very wide connotation. Even a civil court hearing a regular appeal under Section 96 of the Code of Civil Procedure cannot set aside a judgment or decree on the ground that it is against most basic notions of morality or justice. That apart, the civil court cannot even look into the morality. The civil court will only look into the legality, whether the judgment or decree is legal, whether there is any violation of the legal principles of law or otherwise, but not the morality. But here, although we have made the scope of Section 34 very narrow, but on the other hand, we have opened a door where the award has to pass the test of most basic notions of morality or justice. The question rises, what could be the situation where we can say that the award is against most basic notions of morality or justice. So there's a judgment of the High Court authored by me, which is Morgan Stanley, in which the rate of interest was, I think, 36% with monthly rest, and 39 lakh rupees of outstanding loan became 90 crore. So the High Court took the view that this rate of interest, although it is contractual rate of interest, but it appears to be against most basic notions of morality or justice. So the interim application which was there was decided by this principle, and the matter is still pending, and this order is although is under appeal, and the outcome all of you should follow. But there is one more clear example which is cited in that case of Morgan Stanley, which appears to be a very clear case of most basic notions. It is a case where the landlord, there was a long lease of between Kodak Mahindra Bank as a tenant and the landlord in Noida, of which the rent was about 10 lakh rupees. But after 3 or 4 years, when the rent of that area fell down, so the parties executed a supplementary lease deed to reduce the rent from 10 lakh to about 5.5 lakh. And the tenant paid the reduced rent for 2.5 years, but the landlord turned dishonest and claimed the entire amount before and initiated arbitrator. And the matter went to arbitration of a retired judge of Allahabad High Court, where the landlord took the plea that this supplementary lease deed is not registered. The landlord first denied that the rent was not reduced. Secondly, the landlord said that the supplementary lease deed is not registered, therefore cannot be looked into. And the arbitrator took the view that supplementary lease deed cannot be looked into. Therefore, the tenant is liable to pay the initial rent agreed, which was 10 lakh rupees, and not the reduced rent. When the matter came before High Court in 34, the High Court took the view that first of all, the landlord has signed the supplementary lease deed, which his signature is not denied. Only denial is of the registration. Therefore, the plea raised that he had not reduced the rent is a false plea, and Section 209 IPC notice was issued why the case be not initiated for raising false claim. Secondly, the award was against most basic notions of morality or justice. He is a dishonest person who has reduced the rent, signed the supplementary lease deed, but turned dishonest. So award is legal. If we look into legality, there is nothing wrong, because law says that unregistered document cannot be looked into. But if you look into morality, that is against morality. So the court also took notice that the award appears to be against most basic notions of morality or justice. That matter was later on settled after the objections were raised by the court. But the facts of that case are very clear example as to what can be the case where the award is legal, but against most basic notions of morality. Therefore, this is one area on which there is not much case law, except I think these two. Although in associate builder, the principle has been very nicely culled down by the Supreme Court, saying that most basic notions of morality or justice means what pricks the conscience. Therefore, what pricks the conscience is a very wide connotation. Therefore, the first case where we have seen a landlord claiming additional amount on the ground that the document is unregistered, it pricks the conscience of the court. Second case also, according to me, is a clear case where it pricks the conscience. In villages, it happens when a person poor farmer goes to take a loan for the marriage of his daughter, and the loan giver gets the document signed that the loan is not paid within 1 year, then the entire land, the value of which may be 50 times of the loan, would be the lender would become the owner. That, although there is a valid contract, but that claim may go against most basic notions of morality or justice, which is the principle which was invoked in that case. So I think with these two preliminary, discussion, I think that is good enough. And I once again compliment the organizers for successfully conducting this competition. And I also congratulate the teams who have participated and the results would be known very shortly. And the center should continue doing such moot courts with such good, healthy problems. Thank you very much.
Thank you so much, Lordship. Thank you, Lordship, for joining us and accepting our invitation for joining as guest of honor and delivering the keynote address. And I'm sure the Lordship's experience and advice and words of wisdom will be taken and acted upon by the participants and young students who have participated in the competition and our viewers. Thank you so much, Lordship. Now, coming to the stage of the competition for which all the participants have been eagerly waiting for, prize distribution ceremony and valedictory speech by our Chief Guest, Honorable Justice Prasoon, former Judge, Punjab and Haryana High Court. I would like to introduce our Chief Guest. So, Justice Prasoon was appointed as High Court Judge in Punjab Haryana High Court in the year 2013. And after retiring as Judge from Punjab Haryana High Court in the year 2015, Lordship was designated as Senior Advocate by the Supreme Court of India in 2016. In the year 2019, Lordship was appointed as head of Justice Prasoon Committee for Rapid Metro Rail Corporation. Lordship is also founding chairman of the Prasoon, founding partner of Prasoon Law Associates. Lordship has been regularly being appointed as arbitrator in a number of arbitrations. Thank you, Lordship, for joining us today for the valedictory ceremony. Now, I would like to invite Lordship to declare the results for the competition. Lordship, over to you, Lordship.
Whenever efforts are made, one is generally waiting for the fruits. And fruits of labor done are always sweeter than the labor itself. The organizers have not kept any prize for themselves because they are unique, distinct, set apart, and sui generis. That is itself a prize for them, and that is itself a recognition, I think, which goes beyond the words. Now, so far as the results for which the competitions were held, the result is in front of me. So I would, with permission of the chair, Honorable Justice J.R. Midha, would announce the same. The results are as under. It's the first National ADR Tournament 2022. And best researcher is LL14, that is College Sastra Deemed University.
Congratulations to the team.
Mr. Rathi, Sastra Deemed University is located where?
Tamil Nadu, I think, Lordship.
Tamil Nadu.
The researcher is there. He can switch on the camera. He is there, LL14 researcher.
And any representative from them, let us see.
Yes,
yes, Your Lordship.
Put your camera on, ma'am.
She is there, Lordship. LL14 are written. The girl from the team.
Okay, so I'm not able to see on the screen.
Nice.
So, okay. So congratulations, Sastra Deemed University, and many more honors, prizes, and many more feathers in your already well-feathered cap.
Thank you so much, Your Lordship.
And best memorial goes to LL4, that is University School of Law and Legal Studies, GGSIPU.
Yes, Lordship.
Any representative from them?
Yes, Your Lordship.
So congratulations. Please show your face.
Thank you, Lordship. Actually, because of internet connectivity, I can't really turn on my video.
Okay, no problem.
Congratulations, team.
Thank you so
this
much.
is University School of Law and Legal Studies, IPU.
Yes, sir. IP University.
Okay. So best speaker award is LL14, council number 2 of LL14. Name is Fahima. College again, Sastra Deemed University.
Congratulations, Fahima.
Congratulations, Congratulations, galore again for LL14 and College Shastra Deemed University. Let us see who is there from their organizers.
She's there. She's there. Probably on the iPad. She might not be visible, but she's there.
No
Paima is there.
So second runner-up in this category is LL02. That is College Amity University, Noida. Amity University, Noida. Any representative from Amity University, Noida?
Yes, Your Lordship. Thank you so much.
So
congratulations.
Congratulations.
Thank you so much, Your Lordship.
Congratulations. And first runner-up in the category of colleges and universities is LL12. That is College Dharam Shastra National Law University, Jabalpur.
Congratulations to the team.
Anyone from there? Congratulations.
Yes, sir.
To Dharam Shastra National University, Jabalpur.
Thank you, sir.
Thank you, team, for joining.
Very good, nice. And then winner LL14, College Shastra Deemed University. So it means the total overall performance is evaluated. That is what, Mr. Rathi, this means?
Yes, sir.
College Shastra Deemed University.
Yes,
so congratulations to all of you and the participants, their college teachers, as also the participants who have not been able to make it, but it was the competition organized by the most forward-looking person at the Hamza Fair, Mr. Rathi, and his great wife, a spirited woman, a lady who always probably must be encouraging. When we say that there is always some woman behind a man who progressed, in this case of Mr. Rathi, it is his wife, and his wife. Those are three, but that is included in one, his wife, and his wife. So we move further. Justice Midha spoke about associated builders. That takes me back to the law college, where we used to study Hart and Fuller theory, Hart versus Fuller, law, justice, and morality. HLA Hart was the positivist, he was a positive school of law. Fuller used to talk about morality. Hart says law is law what it is in the real form. And Fuller said law without morality is no law, because it will lose its soul. That also is one factor. But when the morality part has been introduced in the statutory law, then it is a recognition of the Indian spirit of morality. Of course, not in the sense of moral turpitude, as the Judgment Associate Builder of Honorable Supreme Court of India says, but it is morality which pricks the conscience. And that is what basically has been our Indian ethos of laws. if we go to the hoary past, we find that the law at that time was not seen in the same sense in which it is seen now. It was Dhamma. It was not Dharma. It was Dhamma, which meant holding to duty. And judge's most important function is holding to his duty towards law, towards justice, and then towards morality too. Because morality as a concept now has been very prominently introduced in section 34 itself. So it in the fields of arbitration, where you have sufficient bandwidth of operation and functionalization of arbitration law, there its location in a subtle way but prominently is a great contribution to Indian law, as also the fact that Indian law is always laced with morality. Though at times morality may not be recognized, but when it is introduced in the statutory law itself, it will have to be taken into consideration. And by going a little further, if we see, we have one concept where morality is seen as the working principle, and that is called Valedictory principle. Valedictory principle again is to the effect that what is the proportionality and it was in 1948, Lord Green in the Valedictory case has discussed this concept. Nearer home in India, it was Justice T.S. Thakur and the bench presided over by him that the Valedictory principles came to be recognized as part of ethos of law recognized in section 34. So when all the demarcated identified areas in section 34 are over, even thereafter, one major principle which remains is the award in any way pricks the conscience of the justice or the judges, that it should not be carried because it ultimately militates and runs divergent to the basic concepts of morality as enshrined in the Indian law. So I am fully in agreement with Justice J.R. Midha, and he himself being a great champion as a judge with the special DNA formulations of such jurisprudential advancements. And not only he knew this direction where to take the law, but also the speed with which it should go. That is the change when it is brought in jurisprudential tones of law, when the creations chiseled out of the great architects of law and justices are seen in great sculpting form. And as we now see, even in digital world, when we see startups, we have seen that even in the field of law, justice and jurisprudential advancements, Indian jurists, honorable judges, and even the students of law have not lagged behind. If we see the judgments of the Honorable Supreme Court of India and even of the Honorable High Courts of the recent years, especially in the field and the time of COVID-19, it would not be exaggeration when we say that Indian judicial system and the judiciary as one institutional of great fortitude has kept the sense of justice alive even in the tough times of COVID-19. So far as digitization is concerned, I think after Singapore, Indian digitization of judicial forums and courts has been remarkable. And now the coming events, as it said, cast shadows before. The students of today and judges of tomorrow, jurists of tomorrow, probably will see and would be surprised as to how the old judges of yesteryears were doing without digitization in the courts. The technology has come as a great help. It is not only a support, but a stable, effective, and very conveniently placed to make the comfort level higher and higher. But we need to take this digitization revolution to the courts, even at the mufassil level. Lawyers must have the benefit of the same as well. Students now coming in the field of legal practice, be it in the courts or through arbitrations, are also the carriers and torch bearers of the future legal field, where people-centric courts and people-centric system will be the not only the need, but fashion of the day. It is the requirement. It is not a luxury. It is the necessity, not the wish. alone. I would tell my dear friends, the students here and their organizers, when you go to legal practice or to arbitration practice or for any other kind of practice in legal segments of different yarn, please ensure that needs and requirements of Indian people in the Indian context of social milieu are quite different from the Western world or from the Britishers, from where we got the Anglo-Saxon judicial system. When we go to the recent developments after Nirbhaya, Justice Verma Committee, having visited only one place where inquisitorial system was being practiced, has recommended certain amendments in the system and which were brought into existence in Criminal Procedure Code, Evidence Act and others, where in some disguised form or the other, in some part, inquisitorial system has also come in. I would talk about inquest which used to be made by executive officers, which now at times legally mandated is that judicial officer has to go into the details if there is untoward demise of some inmate in a jail. Similarly, when we see recording of confessions, videography and other things have come in. Examination in chief or statement recorded under section 164 is not to be repeated. Many more things of this nature, and even with regard to compensation, when the victim, the prosecutrix, has not been able to persuade the court through prosecution department or prosecution of the case, and then no one gets convicted, even then is entitled for compensation. Many more things of social justice, empowerment of downtrodden, destitutes and marginal people have come in. Law is changing, and we could not have heard anywhere in times of yesterday that judge is going to the people for delivering justice. We have seen people moving to fields from the courts in Lok Adalats and such judicial delivery system at the threshold of the people at the cutting edge level. I would only request the students to be in the vanguard of justice administration, either in the form of lawyers or law teachers or judges, to cater to the Indian masses and their legal requirements in the form of justice. Even as a lawyer, empathize with the litigants. I would not say sympathize with the litigant. Empathize with the litigant. See what is his state of affairs and try to redress. Even if you do 1 or 2 cases in a month pro bono, it will be a great help. And when you are with your fellow students, advocates, try to be articulative of Indian ethos, but without shutting your eyes and ears to the happenings globally. We have to keep pace with the developments everywhere. This world has been reduced to a dot. We are without territorial or geographical boundaries. In this digitized world have become netizens and territorial geographical entities, so far as the internet and communication is concerned, are giving way. Worlds of change are blowing fast and very fast. So let us be together in every activity where people are benefited. Sarvajan Hitaya and Sarvajan Sukhaya, good of all, that should be the principle. And again, coming to morality, that should be the guiding factor. And when it is statutorily inbuilt, it has to be guiding factor. Thank you all. And we should prove that India is the most aspired destination for arbitration. And in the years to come, we may see a separate institutionalized bar and other allied agencies for the arbitrations coming up. And a great field where Rashti is, Mr. Rathi is again doing good job. And I must say that he should keep it on.
Thank you.
Making the students move on. Yes. And much more participation of honorable judges. And I am thankful to the participants that they were effectively communicating. But those who have not been able to win the prize, they are also very important. Yes, they shouldn't think that they have not been able to make it. Rather, it is because of them that the others could make it. So now they would also have their field and feelings when they come up and enjoy the blessings of the teachers in their inputs of studies. Those students who respect their teachers, respect their parents, and respect the changing environment around them and recognize and accept it, adapting themselves and not complaining what is happening, they always make their way. People think that they're moving with their costly shoes. It is not. They are moving with their feet and the legs. Shoes may or may not be there, even barefooted you will go on. People think that they are having Rolex watch and probably they see the time better. It is wrong perception. Time would go on whether you wear the Rolex or not. Time would go on. The wood or the charcoal would not understand what worth they have got. It is only a jeweler or a diamond expert who would know how costly is the diamond. Teachers know how effective and articulative their student would become. Students only have little clay, having little malleability. Students chisel them out. And we must owe our existence in field of education to our teachers. and much to those people around them from whom they learn even small things. So my good wishes to all of you, dear students and organizers of their universities and colleges, and organizers and their staff, as well as the people who are associated with them.
Thank you.
They are to be more revered and more respected, so that they may go further, as Guru Nanak Dev said, that those who are good people spread out. They must proliferate, and that branching out of them would really help all others also to go and move forward.
Thank you.
A good leader is not who produces leaders and followers. A good leader is he who always produces leaders like him and is never jealous of his co-students or followers going ahead of him. And that is what should be done. Thank you all. Thank you, Justice Midha. I must say that the great opportunity to have Mr. Midha, Justice Midha here. Many more opportunities Rathi would provide. And in November, there is some event. I think when we meet there, even as audience, we don't mind. Thank you.
Yes, Lordship. Thank you, Lordship, for accepting our invitation for joining as chief guest and delivering the valedictory address. I'm grateful that Lordship for sharing the pearls of his wisdom and experience with the participants and viewers. Now, I would like to invite Ms. Riya Rathi, founder and editor of latestlaws.com, to deliver the vote of thanks. Over to Riya.
Thank you. I would like to thank Honorable Justice J.R. Midha and Honorable Justice B.B. Prasoon for enlightening and motivating all of us with their words of wisdom, and we are obliged by their graceful presence today. I would also like to thank all our distinguished judges for the final, semi-final, and the preliminary rounds. The time they have taken out from their busy schedules is definitely going to encourage budding lawyers. I would also like to thank all the participants for their enthusiastic participation. I hope it has been a great learning experience for all of them. I would also like to thank our law school partners, Vivekananda Institute of Professional Studies and North Cap University, and our law firm partner, Lexidam and Rathi. And last but not the least, I would like to thank our court masters and the team, latestlaws.com and the IDRC. Thank you.
Thank you so much, Lordship. Thank you, Justice. Thank you for joining. Thank you for the team for participating. Obliged to have you. Thank you.
Nice. So thank you. Thank you all. Thank you all.
Thank you, Prasoon ji.
Thank you.
Thank you, sir. Thank you.